National Medical Commission Act. And on this very beautiful Sunday morning, Dr. Nagpal wants me that how it can be declared unconstitutional. Why is it unconstitutional? I'll try to find out, and I'll try to share my thoughts on this act with all of you. So friends, whenever an act is made, whenever the legislature legislates, there is always an objective. And if you read the act, there will always be a statement of object. So what was the objective behind this act? In fact, the very first line says, an act to provide for a medical education system that improves access to quality and affordable medical education, ensures availability of adequate and high quality medical professionals in all parts of the country. High quality medical professionals. The act has been made to facilitate high quality medical professionals, and this is what the act is undoing. The real purpose of this act, not written, but within the time constraints that I have, I'll point out. The purpose is to promote quackery in the name of medical pluralism and a new term, community health provider. What it means, I don't know. We'll all try to find it out. And I'm sure we will never be able to find out. Yeah. And probably the government wants to run this big legal business of medical schools. Legal. Let me point out. Hierarchy. These are the various bodies. There is a National Medical Commission. There is a Medical Advisory Board. There are 4 autonomous boards, and there is an advisory committee of experts. This is at the central level. Then there are state medical councils. How will they operate? The state governments have to decide. But the ultimate veto power is there with the central government. National Medical Commission, and I'll try to explain it in very simple terms. The first line happens to be a little legal, it was unavoidable. It has legislative powers. What it means is, it can make laws for doctors, it can make laws for medical students, it can make laws for medical education. It has the power to legislate. It obviously has powers to execute it. And then it has the authority to decide disputes. The most commonest of them would be a patient suing a doctor. Ultimately, the appellate authority happens to be the NMC. So these are the functions. But unfortunately, independence of such an important body is absent on the face of it. No accountability, no transparency. The control of Government of India is patently visible. It is a Government of India enterprise. Let us call it by that. No elections to NMC. There were elections to MCI earlier. You all know that. Only appointments. In the commission, I am talking about the National Medical Commission, the government appointees have the majority, and I am including the vice chancellors of medical university, 10 in numbers, in government appointees. You and I don't appoint them. You will be electing members of your state medical council, they will go here. Out of 33, only 10. And these members of National Medical Commission, even after demitting office, there are certain provisions. At least for a period of 2 years, they would be under some control of the government. So even if they want to say something, they would not be saying so. The quorum for meeting is half, and the majority will decide. So effectively, the union government will decide whatever has to be done. All appeals will finally come to the central government. It is the final appellate authority. Obviously, you have a right to approach the High Court. You have the authority to approach the Supreme Court thereafter. Even to the state governments, it is the central government which will be giving directions. And as if this was all not enough, the central government has retained the powers to supersede National Medical Commission. And this supersession is possible in one stretch for as many years as they want, without interference of courts. Doctors were very agitated. It is the courts which are granting injunctions and our state medical councils are not working weight. Now even without courts, the central government is going to supersede if they want to. Probably that day will not come. The majority is brute, 33:10. So let me answer the question now as a lawyer. And the challenge obviously here is that you all are doctors. I am not speaking before a constitutional court. I'll try to explain in as simple terms as possible. In Constitution there is one Article 19, fundamental freedom, which every one of us has it. And even in emergencies, those fundamental freedoms cannot be touched. Sacrosanct, holy cow. Article 19(1)(g) happens to be one such article which gives every citizen of this country freedom to practice any profession. And if the legislature makes any law, if the executive implements a law in any way which interferes with your constitutional rights, with your fundamental rights, it's ultravires. It's unconstitutional. It has to be struck down. This law, in fact, interferes with your right to practice modern medicine. And why does it do so? Because this law is going to be used. It's patent, nothing hidden, very clear. I'll come to those provisions. We'll read those provisions. The government of the day wants to authorize incompetent persons to practice modern medicine. As good as that. So it interferes with your right, with your freedom to practice your profession as a doctor. And doctor, by doctor now I mean practitioner of modern medicine. There is discrimination. Article 14 of the Indian Constitution. The state will not discriminate against any citizen. Here it is discriminating practitioners of modern medicine. I am a lawyer. We have our bar councils. We elect our members to the bar council. Chartered accountants have their regulatory body. Company secretaries have their regulatory disciplinary bodies. Members of the profession, they elect their members. How would an advocate know what are the challenges that are faced by a doctor? And in fact, here there will be all babus only, not even advocates. What was the reason? What is the rationale? MCI was corrupt. Is that the rationale? It may be corrupt. Is this the solution? No, this can't be a solution. There is no basis for this discrimination. Why this profession has been singled out and you have been given a regulatory body where you don't have a representation or your representation is minimalistic? No justifiable reason to discriminate. So the state is failing in its policy. It is discriminating doctors vis-a-vis the other profession. That is why this law is ultravires. And friends, Article 21. No one shall be deprived of his life and liberty without following the procedure established under law. They have put a procedure, but that procedure is unreasonable. I have already shared with you. How will the babus know the pain points? There is a rationale why professional bodies have elected representatives. You know the pulls and pressures, you know the pains, you have the solutions. Government appointees having a sword hanging over their neck, what justice are they going to do? I'll go a step further. By giving authority to incompetent people to practice medicine, and medicine I mean modern medicine, not other types of medicines. Isn't the government playing with the life not only of doctors? As doctors, it is playing with your life because this is your profession, this is your earning, this is your livelihood. They are also playing with the livelihoods, they are also playing with the life of a common person. Someone with a 1 year or 2 year experience or a 3 year experience will become a community leader or God knows what name they have given. And he will deliver health care. And the alternate path is they will deliver modern medicine. Isn't this a direct threat to the life of the citizens of this country? It is therefore a threat to public interest. These are the three broad propositions why this act happens to be unconstitutional. There is one section 50, let us read it. And then we all are free to interpret it in our own ways. It says that joint sittings of commissions, central councils of homeopathy, Indian medicine, to enhance interface between their respective systems of medicines. And in fact, section 53 is absolutely clear. And that it says, modules or programs that may be introduced in the undergraduate course and the postgraduate course across medical systems and promote medical pluralism. Supreme Court of India has said in so many words, a non-allopath practicing allopathy, someone who has not got the qualification in Ayurveda practicing Ayurveda, it is quackery. Now you are making a law to make that quackery legal. there is a community health provider. This is a bigger problem. It says that under this act, MBBS, MD, all that is fine. There would be community health providers. The commission may grant limited license to practice medicine at mid-level as community health providers to such persons connected with modern scientific medical profession. So now they have even done away with Ayurveda doctors prescribing allopathic medicine. Another cadre is now going to come. The writing is there on the wall. Community health providers. And they will be taught something in modern medicine. Why don't you cut down? If you are going to provide the community health provider, you think you can impart this education in 2 years. Cut down the time for giving MBBS degree to 2 years. So there will be nurses, there will be allied health professionals. Good, they are required. What about these community health providers? Big question mark, friends, which very clearly points out to the intention, the unholy intention, the real intention of bringing this act. In fact, there is a very special provision. Cognizance of offence under this act will be taken by courts only if an officer of the National Medical Commission gives it in writing. A common man cannot, a doctor cannot make an complaint to the police station or to the magistrate. No, those powers have been curtailed. Why? No reasons. There is one provision which I am sure would be very helpful to Dr. Nagpal. Food for thought, sir. Section 34 says, and the act is in, I presume it has been implemented 1.5 years back. It says that anyone who does not have, or who is not registered with the State Bar Council or the Medical Council of India or the National Medical Commission, if he or she is practicing modern medicine, then he may or she may be punished, and this punishment will be up to 1 year. Fine may be extended to 5 lakh. How many persons have been arrested till date under this provision of law? Has quackery stopped in India? No. These are rumors. I am not a doctor, as already introduced by the chairpersons. But yes, there are rumors that the old syndicate from MCI is still calling the shots in NMC. So what purpose have they achieved? Out of the 4 autonomous boards, chairmen of 2 boards have resigned. One of them happens to be a very good friend of mine. He came, he took advice. He was literally in tears. Resigned, good. This is the state of affairs, the current status. Those who are there, and you may ask, your colleagues would be there. On the NMC, feeling frustrated. What is the way forward? Now, not as a lawyer, but as a common man. Your societies, your IMAs, your associations, they will have to be more active, they will have to raise voice. Law is already there in place. Public awareness is required. Under this act, rules have come, few more will come, regulations will come, executive orders will come. They need to be challenged. friends. And there is a small advice to the government of India. You want to run this business of medical colleges. Good, good. Governments all over the world, they are running businesses. Even in India, the governments do run businesses. You also run the business of medical colleges, no harm. But not under this National Medical Commission Act. For that, you can make some autonomous bodies, some statutory corporation, government companies, perfectly legal under the administrative laws. But spare the medical profession. Not only for doctors, but for the common people. One small request, and that request is to my friend. I am a fan. At times, he does take legal advice, Dr. Neeraj Nagpal. Sir, isko challenge mat kariye. You have already burnt your fingers. Good. Whatever can be done in a democratic way, let us do it. Plus, don't challenge it in the courts. Nothing will come out of it except frustrations. And in spite of saying all this, I know that probably Dr. Neeraj Nagpal by now, the grey cells would be working how to challenge it. Probably he believes in what the Bhagavad Gita says. Yato dharmas tato jaya. Ultimately, the truth will be victorious. Thank you, friends. Thank you for listening.
Thank you, Dr.